Your estate plan is definitely not just a plan for when you pass away. A trust and a durable power of attorney work together during your lifetime. So please don't believe today that not having an estate plan only matters when you die. Let's talk about how your estate plan takes care of you during your life. So when you begin your estate plan and you fund your major assets into a trust, that trust is going to provide for you during your life in a number of ways. Let's use Ron and Dorothy as an example today. So during their life, of course, Ron and Dorothy can use any assets from their trust. They can sell, trade, lease out assets, spend it however they like during their life. Just because it's in their trust doesn't remove it from their control at all. Now, suppose either Ron or Dorothy reach a point where their capacity is somewhat or extremely diminished. Now, the other will be able to continue to act as trustee of their trust, and even if they want, maybe add one of their children as a co-trustee if they like. And of course, the trust assets can be used for regular things during the life, as well as caring for the spouse who now has a somewhat or extremely diminished capacity. And it's important to know that this is seamless. Neither has to go to court or have any legal action to be able to access the trust assets and care for the other spouse. Now, suppose Ron, in this example, suppose Ron passes away. Just as before, the trust assets remain available for Dorothy's life, for her care and support, whether she was the one with diminished capacity or not. If she's fine, she manages the assets of the trust as a trustee, and if not, maybe one or more of their children become co-trustees to handle those things. And either way, the trust assets are still available, well under the control of the survivor of Ron and Dorothy for their life. Now, how does the power of attorney fit into this? So let's stay with the Ron and Dorothy example. They were smart. They signed powers of attorney naming one another to be able to act on their behalf. So as long as they are alive, that power of attorney is active and gives authority for the other to act on their behalf for health care and financial and property matters. So let's go back to our similar example. Suppose one of them begins to suffer from dementia and needs assistance. Ron and Dorothy are ahead of the problem. Rather than one of them needing to go through the courts and seek appointment to act for the other as guardian, which has authority over the health of the person, or conservator for property and financial matters, you usually do both of these together. Rather than do any of that, they're already empowered to act under the durable power of attorney. So when one of them starts to suffer, the other acts under the power of attorney. By the way, it's called a durable power of attorney because it remains effective during periods of absence or incapacity of the principal. The principal is the one who signs the document naming the other to be able to act on their behalf. So with this durable power of attorney, it really works well in conjunction with the trust. Again, the trust provided the assets, so it's seamless that the assets are there for the well and the not as well spouse. But with the durable power of attorney now, the well spouse can take care of a huge variety of things on behalf of their spouse. These are a few examples. This isn't an exhaustive list, but just some common things that will definitely sound familiar. They can handle banking, taxes, insurance, legal matters, claims, settlements, purchase, sale, lease of real estate and vehicles, financial management, speaking or acting on the other's behalf with the financial representatives for the family. They can act or speak for the other with respect to medical visits, information and decisions, and even small things like subscriptions, library books, or utilities. So again, that's a small list, but you can see it really runs the gamut of the kind of things that one can take care of for the other. So please today, don't go on believing that estate plan is only for when you pass away, because it's important long before that for a number of reasons. Moreover, if you get to a point during your life that you no longer have capacity, it can be too late at that point to sign an estate plan, and your spouse and your family may need to go through the expense, the process, all the time it takes to go to court to get you appointed a guardian and conservator. And while it may seem less than logical, your spouse without a power of attorney or some kind of court appointment doesn't have some automatic authority to act on your behalf. Just because you're married and maybe have been married for a number of years, your spouse doesn't get to, I'm sure you're familiar with this, they can't go sign a contract in your name. They can't go to the bank and deal on your behalf unless it's, if it's a joint account, that's a different story. But a lot of things you've taken for granted that seem like small things pop up, and when someone needs to act on your behalf, it's very difficult without a power of attorney or a court appointment. So again, your estate plan is definitely not just a plan for when you pass away. A trust and a durable power of attorney work together during your lifetime. I hope this helps you out and clarifies this topic a little bit. Again, I'm Dan Covington. You can always find me at Estate Plan Kansas.